Joining me today is Dr. Michael Arnheim. Dr. Michael Arnheim is a barrister in London, which, if I understand correctly, is sort of an elite lawyer position within the judicial system in the UK. He's also an American law and U.S. constitutional scholar. Dr. Michael is also the author of 22 books, including titles such as Principles of Common Law, Anglo-American Law, A Comparison, Practical Guide to Your Human Rights and Civil Liberties, and the book that we'll be talking about today, U.S. Constitution for Dummies. Thanks for joining me today, Dr. Arnheim.
Sure, thank you. And of course, this is the second edition.
Yes, this is the second edition. I read the first edition originally. Can you even see that? It looks like it's upside down. Okay, there you go. So I read the first edition, and that was about a month or so ago. And then I discovered, you actually brought it to my attention, that you have a second edition I wasn't aware of. I just finished reading that like 3 hours ago. Okay. So unbelievable tool, unbelievable resource. As far as trying to get yourself familiar with the U.S. Constitution, it's a fantastic way to dive into the topic. It's so good at not only providing the basic components of the Constitution, but also explaining the story, the arguments, and the confusion surrounding parts of the Constitution. It's also easy to read, and it's funny. You crack a lot of jokes in the book, which is cool. So big fan, big fan. I tend to love the Dummies books in general, though. I've read the Personal Finance for Dummies book. I'm also reading the Insurance for Dummies book right now. The Dummies books really seem to speak to me. I'm not sure why, but all of the Dummies books I've read, this is my favorite by far. So
well, thank you very much for that.
Yeah, thank you for joining me. So originally I was going to start off with a series of questions with the purpose of laying out some background on what led up to the Constitution, what influences did the founders and framers draw on, such as the Magna Carta and English common law, what was wrong with the arrangement that predated the Constitution, namely the Articles of Confederation, and in what ways does the U.S. Constitution, in what ways is it similar to the Constitution of Great Britain, and what ways is it different? But then I wrote the rest of this interview, and I realized I was trying to cram 4 hours of questions into a 1 hour show. So for the sake of time, I'd like to offer you a chance to quickly lay out the foundation and backstory of the U.S. Constitution as you fit, and even if you want to compare it to your system over there, that would be cool, as long as it's within 5 minutes or less. Okay?
Sure. Well, thank you for that, John. I really appreciate it. And hello, everybody. Thank you for tuning in. It's a tall order, but basically it's about how 13 colonies decided to break away from the mother country and managed to make a go of it. With one or two ups and downs. The Constitution, the British Constitution, is still unwritten. So the idea of writing it down is really a fairly new idea, which came from America, although there was also a Polish one similar to that. Well, it's not similar, but the idea of writing it down. And actually, there was a written British Constitution in the 17th century during the Cromwellian period. Well, that didn't last. But there are similarities, of course, because the American Constitution is more or less modeled on the British Constitution, which is what the American colonists were familiar with. But it also made a deliberate effort to differ from the British Constitution in many respects. Well, they didn't want a king. So that got chopped out. Originally, there was no executive at all in the original Constitution, but the Confederation, not to be confused with the later Confederacy, but then they realized that they needed a strong executive, and that became the president. But one thing they didn't seem to understand is that there was a distinction between being head of state and head of government, which even in Britain was not understood at that time and has developed only by accident, like most things in Britain happened by accident, where now the Queen is the head of state, but she's not the head of government. There's a prime minister who's the head of government. In America, the president is the head of government and the head of state. Actually, I think that is a pity in a way, because having a separate head of state has turned out to be quite a good idea of someone who is above politics. And it's been copied in many countries throughout the world, not just monarchies, but also republics, like Germany, or Switzerland, obviously, Finland, many countries where the president is very, very much, I wouldn't say only a figurehead, but essentially is above politics. One of the problems that's emerged in that regard in America is with this kneeling at football games and so on, taking the knee, because people are attacking the country by doing that. They're doing that during the national anthem, which is attacking the country, when in actual fact they're not attacking the country, they're not attacking the head of state, they're attacking the government. They want to attack the government, but because the two are rolled together in America, they have to do it in that way, and that looks as though they're actually unpatriotic. So I think it would have been good if the president had been just the head of government, or if someone else had been the head of state and the president had been head of government, or vice versa. And there are many other differences as well. I won't go into it all, but in particular, in Britain, you can never have a situation where the executive and the legislature are against each other or are run by different parties, because the executive emerges out of the legislature. Parliament, there's a parliamentary election. There's no separate election for the executive. There's a parliamentary election, and whichever party has a majority in parliament becomes the government. And the government really controls the legislature.
Okay. That
may or may not be a good thing. All right, well, I mean, I'm going through, I'm taking much longer than I should.
No, that's fine. Please continue.
Magna Carta, you mentioned. That's, yes, it's a name to conjure with, more so in America, actually, than in Britain. And it's got to be remembered that this dates back to 1215, the year 1215, when I was still fairly newly called to the bar. So it's quite some time ago. And King John was forced to sign that by the barons. The concessions he made are not to the ordinary people, but to the barons. That has been, of course, that has been widened since then. But it's sometimes suggested that the idea of a jury trial, the idea of habeas corpus, the idea of no taxation without representation, all come from Magna Carta. Well, only in the vaguest possible way. Only in the vaguest possible way. There is only very few clauses of Magna Carta survive in the law in Britain today. The idea of trial by your peers, I mean, that's eventually turned into jury trial. But actually, of course, unfortunately, in Britain today, jury trials are practically non-existent now, except in cases of serious crime. Oh. So in some respects, the American Constitution is closer to the old British Constitution, and I think jury trial is one of the really good things about it.
Okay. And so the Magna Carta is probably more revered and more romanticized by us than by you guys.
It is, and that's why the Magna Carta monument, which was put up in 1957, was actually paid for by the American Bar Association, although it's in Runnymede in England, where King John signed the agreement. Why do you need a book on the Constitution, or do you need an explanation?
Yeah, so that was actually my next question. I was going to ask you in chapter 1, you write the whole text of the Constitution takes up just a few pages of print. And you go on to ask, so why do you need a book this long in order to understand it? So that's a great question. Let's start there. So why do we need to read a book this long to understand it?
Yeah, and it is quite a long book. And it's actually got some very nice pictures in it as well, I have to add.
Yes, it does.
Actually, you do better reading it in Kindle, as far as the pictures are concerned, than the print version.
Okay.
Because the print version only has the pictures in black and white, whereas Kindle has it in glorious Technicolor.
Oh,
so
nice.
And of course, the Kindle is a lot cheaper. But just a little plug there. Well, 3 things, as I put in the book. First of all, old-fashioned language. Secondly, ambiguity. And thirdly, the need to interpret, because in such a brief document, it's not always as clear as it might be. I think one of the best examples of all I can give is, that's of ambiguity, is the provision about the vice president taking over from the president when the president is disabled or has died in office or has been removed. And that, the first time that came into play was when William Henry Harrison, elected in 1840, and then inaugurated in those days on the 4th of March, 1841, and decided to give a very long speech. I think it's still the longest inaugural address, without wearing proper winter winter overcoat and anything. And he was the oldest president up to that time. He was 60 years old, and he caught a chill and died within a month. I mean, whether he really died from his inauguration, I don't know, but he was there for 1 month before he died, and the vice president, John Tyler, took over. Now, Harrison was a Whig, and the Whigs were not too bothered about political ideas or programs. They just wanted to win. And so they got Tyler, who was really a Democrat, a Southern Democrat, as the running mate, not thinking that he would ever become president. But anyhow, he took over from Harrison, and the question was he acting president? Everyone knew he was standing in for the president now, but was he the acting president? Was he maybe still vice president in a temporary capacity as president, or was he the actual president? And the Constitution was not clear, but he made it absolutely clear that any letter addressed to him as acting president or vice president, he would tear up immediately, and he had to be recognized as president. He managed to get that through Congress, although he disagreed with Congress on practically everything else, and he was at total loggerheads with Harrison's cabinet, which were all Whigs, and he was not a Whig. So that actually changed the Constitution by virtue of the practicalities. But the actual Constitution, the wording didn't change until 1967, when it was provided finally that yes, the president, the vice president does become the president, not just acting president.
And after reading your book twice, there's just so many examples of things that seem to be left out, or things that are vague.
Well,
It's
yes,
really surprising.
well, what is more surprising actually is the way the founders or the drafters, they're not exactly the same people, managed to think of so many things that were important. They couldn't think of everything, but it is a brilliant document, actually. It's a brilliant document.
Sure. Now, the vice president that became president that you just mentioned, is that the one that they jokingly called his accidency?
Yeah, exactly. He was called your
accidency.
his accident,
Instead
because
of, yeah.
president by accident.
Yeah.
And no one was really expecting that. The vice president, position of vice president has always been slightly anomalous, and in fact, I think it was Franklin Roosevelt's first vice president who described the vice presidency as being not worth a bucket of spit, as it's now. You see it reported now, it's a bucket of spit. Actually, it was a bucket of piss.
Oh. But that's until the president dies. Then it actually works out.
Of course.
Which is probably going to happen sometime soon with Biden and Harris. Not to get political, but
well, it could be. It could be. I usually refer to as Vice President Camel.
Yeah. So, you touched on something before briefly, but I want to revisit it and ask you, before the Constitution was a thing, our original document was the Declaration of Independence.
Yeah.
But was the Declaration of Independence the birth of one nation or 13 nations?
Well, I think if you read it, you'll see it is 13 nations at that stage.
Okay. So
it still wasn't one nation, because it still went through the stage of the Confederation, which also wasn't really one nation, but it was with the Constitution, the idea being a closer union, that it really became one nation. So now, although the term United States, plural, is used, it's always used as if it's a singular. The United States is a country in North America. You wouldn't say the United States are today. That would be completely wrong. So it's now definitely one nation, I think. But and of course the motto, e pluribus unum, from many one, and from more, literally one. And but initially, the Declaration of Independence is actually a Declaration of Independence of 13 individual states, and the wording there is all in the plural,
Now, when the Constitution was ratified, was it immediate that all of a sudden we are one nation, or was it more of a federalist system that kind of grew towards this more centralized control over time?
Well, yes. I mean, of course, the confederation means a looser union than federation. It was set up as a federation, which means that the states still had, and of course still do have, quite a considerable amount of autonomy. And there were certain special concessions made to the southern states to bring them in, because they were less populous. They had smaller populations than the northern industrial states, but what they had were slaves in the south. So the slaves did not have the vote, of course, but there was a 3/5 rule, which actually is still in place today in the representation of the states in Congress, in the House of Representatives, that every southern state, the population of the southern state would be based on the population of the white population plus 3/5 of the slave population, even though the slaves didn't have a vote. And that was what brought the southern states in. Otherwise, they wouldn't have joined. The 3/5 rule.
And that was, as far as I understand, that was a compromise, wasn't it? Because they would have preferred that the slave population be counted 1 for 1, but that makes no sense because they can't vote. Yeah.
Well, of course, no, the alternatives were not to count them at all, because they didn't have the right to vote, or to count them as individuals, which would make no sense because they didn't have the vote again, or to have some compromise, which this was, 3/5. So, and that was what cemented the Union, as it were. And all the early presidents, except for John Adams, came from the South, mostly from Virginia, and were slave owners. George Washington, I know, unfortunately, their statues are now being toppled all around the country because of that. Jefferson even had an affair with one of his slaves, and so on, and a lot of publicity about that lately. But John Adams was the only, because he came from Massachusetts, where slavery had been abolished, he was the only one of the early presidents who was not a slave owner, purely because of that reason, that he was from the North.
Okay. So when the Constitution was written, the preamble starts with "We the people," which sounds very democratic. But our founders and framers didn't really set up a democracy, though. They set up a republic, or a quote-unquote democratic republic. Now, in a real-world, nuts and bolts kind of way, what's the difference, and why did they prefer a republic as opposed to a democracy?
They were very afraid of the lower classes. That's why. The people we're talking about who set up the United States were all actually members of the elite. George Washington was the richest man in America, largely through his wife, who was the widow of an extremely wealthy man who'd left lots of slaves and everything, property to her, which became his. So they all were extremely well off, well educated, and they weren't inclined to share power with the hoi polloi, with ordinary people. And initially, the vote did not extend even to all white males. Now, you won't see that in the Constitution, because this is one of the areas left to the states. The states decided who had the vote. Some states, in fact, women even had the vote in the early days. In certain, they mostly had to be property owners, though, not huge numbers of them. But that was the exception. But for the most part, it was property-owning males who had the right to vote initially, and this would have been about 10% of the white male population only initially.
So the "we the people" part, was that just like a sales tactic or a ploy to get people to embrace the Constitution?
Oh, yeah, I think so, and also similar to what it says in the Declaration of Independence about all men being born equal, and that was written, drafted by Thomas Jefferson, sitting on top of a menagerie of slaves.
Yeah.
No intention of giving slaves the right to vote. And although he is regarded as highly democratic by comparison, for example, with Adams, but it only really became democratic in any modern sense from the time of Andrew Jackson. And that's why we talk about Jacksonian democracy, because he extended the vote. From his time on, in the 1830s, the vote was extended to practically all white males. And then, of course, it took another 100 years until 1920 before women got the vote. And of course, blacks got the vote in 1865 from the as a result of the freeing of the slaves, emancipation, and the amendments to the Constitution. But although in practice blacks did not have the vote, because again, this was a state-controlled system. Voting is still today controlled by the states, and of course, for many years after the Civil War, after Reconstruction, as it's called, right up to the 20th century, you can say, blacks were often denied the vote by either being required to pass a literacy test, which usually was made very difficult. They had to usually read bits of the state constitution, which was written in highly legalistic language, or they had to pay a poll tax, and mostly, of course, they weren't very wealthy. They couldn't do that. So that was a way in which blacks were deprived of the vote. But even today, of course, voting is still state-controlled, and that's why there's been all this fuss in recent elections, including the 2020 election, and of course the 2000 election, where it was Florida. Florida had a particular form of voting with the hanging chair and all that, which didn't affect other states because they didn't have that system. Florida has given up that system now for very good reason, because that caused a lot of confusion. And in the end, that decision of who was to be president in the year 2000 went to the Supreme Court, which really has no role in this sort of thing at all, or shouldn't have.
Okay, so I'm going to jump ahead a little bit and do things a little bit out of order. But since you're on voting right now, I was going to ask you, is voting ID unconstitutional?
No, not at all. Again, as I say, this is a matter for the states to decide.
Okay.
And my own view is that voting ID, voter ID, should be obligatory.
Yeah.
How otherwise are you going to know who is actually entitled to vote?
Yeah.
It's partly a question of citizenship. There have even been accusations that some people who are not even citizens have been allowed to vote. But that aside, they may or may not qualify under residency rules. They may not be from that state. They may be from out of state. It may have been brought in to vote for a particular party when they don't even belong in that state. And certainly there have been cases where it's known that dead people have voted in Illinois, in Chicago. It was well known that whatever you voted when you were alive, when you died, you were always a Democrat. And John Kennedy probably was elected by the dead people of Chicago. To maybe in Texas as well. I think Lyndon Johnson once boasted that his granddaddy had voted for him. His granddaddy had been dead for many years.
That's funny. So the reason I ask is I know that that's not the way they normally frame the argument against voter ID. They're not usually saying it's unconstitutional. They just say that it's racist. But they're saying that it's kind of like the like you mentioned before, the voter tax, I think you called it, or fees, whatever it was, or the literacy tests and all that kind of, they're lumping it in that category and saying that it's specifically designed to prevent blacks and minorities from voting, which I think is a little crazy.
Yeah, well, I think it's a bit overblown. It may well be that poorer people have more difficulty getting proper ID. That's possible. But a lot of states have gone out of their way to make it very easy to get ID. You go to the DMV.
Sure.
Even if you don't have a driver's license, you go to the DMV, you get a photograph taken. It used to cost, I think, something like $10. I think in many states, I think that fee has been waived. So as long as you can get yourself to the DMV, they'll take a photograph for you. They'll give you a card, which is to all intents and purposes like a driver's license, only it says round the edge, this is not a driver's license. And it's used for ID purposes.
Yeah. Did you see the video of one of these YouTube people? He did like a man on the street type video where he went into college campuses and he asked mostly white people, is voter ID racist? And pretty much everyone said yes. Then he went to he asked them, well, why is it racist? They said, well, they probably wouldn't be able to get the ID. They're not sure how to do it and that kind of thing. Then he went to Harlem and he asked all the black people that he found walking around the streets of Harlem, and all of them said, that's crazy. Of course it's not racist. I have an ID. I know where the DMV is. You know, it kind of reminds me of just this past week, Biden made a comment that black people are not able to get certain benefits because they don't know how to go on the internet. I don't know if you heard that. They don't know how to go on the internet and apply for it. You know, they're not internet savvy. And, you know, I know a lot of black people, and that was a surprise to them. They had no idea that they didn't know how to use the internet.
Well, it's true that poorer people will probably have less access to the internet, less knowledge of the rules and so on. But there's so much help available out there now,
sure,
especially that I don't think there's any excuse. And I think that the real point is that you've got to guard against people who are not entitled to vote voting. And that's a serious problem.
Sure. Which I believe there was probably a lot of that in 2020.
That's still going.
Yeah. And that's definitely something I want to discuss with you today a little bit.
Sure.
Okay. So let me move along. So when the Bill of Rights was originally written, was it meant to apply to the states, or was it simply referring to what the federal government can and cannot do?
Well, originally, the Bill of Rights applied essentially to the states, it seems. But as time has gone by, the idea it's been expanded so that now all the articles of the Bill of Rights.
And was that through the 14th Amendment?
The first eight amendments now apply to federal and to the states as well. Originally, it was originally meant for federal only, but the idea is now that it extends to the states. The first eight, anyway. But certainly, the whole Constitution is really only about federal government. So therefore, it was only the federal government that was obliged to follow what was said in the Bill of Rights. It was purely for the federal government because the whole Constitution is about the federal government. Each state has its own constitution, after all. So the amendments, the first eight of those 10 amendments have now been extended to cover the states as well as the federal government.
Okay, so the first eight
was only for the feds. It was only for the feds originally.
Okay, so it's the first eight. It's not all of the amendments. And
this has been done piecemeal over the years by the Supreme Court. There are a couple of exceptions still, like grand jury. That is still not applicable to all states unless the states want it. That doesn't apply automatically, and not all states have a grand jury. Also, jury trial in civil cases. Those are the two exceptions from the Fifth Amendment that still don't apply automatically to all states. But otherwise, all of the first eight amendments do apply to the states as well as to the federal government, which originally was all it was all intended for federal. The last two of the Bill of Rights do not apply to the states, and some people have rather dismissed those, the 9th and 10th Amendments, as being not very important. The 9th Amendment has been described as an ink blot. But unfortunately, Judge Robert Bork described it as an ink blot, but I think he was very wrong. Very wrong.
So you said that this happened over time, piecemeal, but did the 14th Amendment kind of solidify a lot of this as far as the Bill of Rights, or at least parts of it, applying to the states?
Yeah, the amendments made after the Civil War, 14th, 15th, 16th Amendment, those amendments were done primarily to bring the southern states into line, to bring them to book. They're really quite punitive, and they were designed, yes, to bring the southern states who had been defeated in the war between the states, as they say in the South, or the Civil War, to bring them into line. So yes, that certainly had something to do with it.
Okay.
The scope of the 14th Amendment, particularly, has been so greatly widened that I can't believe that it was intended at the time, even though the people who drafted those amendments were not in the same league as the original drafters. I call them the Little League drafters. They were very, very partisan and very angry men, and they didn't have the same educational background or general. They weren't of the same class on the whole as the original drafters, really.
Yeah.
So, 14th Amendment, the due process clause of the 14th Amendment has been so widened. Of course, there's a due process clause in the 5th Amendment as well, but it's not. It goes so far beyond what was intended. In fact, we've got things like abortion, privacy, abortion, gay rights, gay marriage, all that coming out of due process, really.
Kind of reminds me of the Commerce Clause.
Yeah, the Commerce Clause has also been interpreted in very many ways.
Yeah,
which has caused a lot of fuss. Not as much as the due process clause, I would say, but because it's more to do with economic things which affect a fewer people.
Yeah, but the problem is it's been used for things that have nothing to do with economics and interstate commerce. So it's
it definitely has.
So, and I read in your book that the Supreme Court case of 1833, Barron versus Baltimore, the court declared the Bill of Rights binds only the federal government, not the states.
Yeah,
so
that's right.
So it definitely was only for the federal government up to a certain point. And I think this is I think this is one of the things that people struggle with the most in understanding the Constitution, is this kind of dynamic between the states and the federal government, and who controls what was the original intent, how does it work? That's why.
As I said, the original Constitution is purely for the federal government.
Sure.
The federal government has no direct authority over the states, except within the framework of the federation.
Sure.
But the federal system of government. But each state has its own constitution. So that's why voting rights can differ from one state to another. They don't at the moment because, of course, there are amendments to the Constitution which have given everyone over the age of 18, for example, the vote. They gave the vote to women. That all was done by amendment to the federal constitution. But that meant that the states had to abide by it. But otherwise, the states still do have a fair degree of latitude in the way they run elections, as I was saying before. But yes, it's all intended, the original constitution was intended purely for the federal government.
Mm-hmm.
But up to 1833, which is just the end of the time when John Marshall was Chief Justice, that was the position. And then later, quite a lot later, things started to change. But that was really only after the Civil War, when they wanted to bring the southern states to heel.
Yeah. But it is confusing for the average working guy like myself. I'm just a working guy. You know, I'm not a constitutional scholar. And that's why your book, U.S. Constitution for Dummies, really is so awesome to help get people up to speed on this kind of stuff. Because after I started reading this book, I can hear a lot of my Facebook friends talk about the Constitution, and I'm already starting to see where they're a little bit off in their information, you know. So it's definitely.
Well, unfortunately, the Constitution is a political document, so therefore people will interpret it in accordance with their political preferences. And for a long time now, the Constitution has been practically monopolized by the Supreme Court, the U.S. Supreme Court. That was the fault of John Marshall, who back in Marbury and Madison, the case Marbury versus Madison, 1803, more or less monopolized control over interpretation of the Constitution, which was never intended to be the case. Thomas Jefferson went wild over that. He was absolutely livid. He absolutely hated John Marshall, who was actually a distant cousin of his, and he was planning on having John Marshall impeached, but he never quite had the courage to do it. And John Marshall probably wouldn't have been. Everyone liked John Marshall, actually, except Thomas Jefferson, of course. Everyone thought John Marshall was such a charming man, such a mild-mannered person. He was, you know, delightful to talk to, very witty and all that. And I think his fellow justices in the Supreme Court all liked him. They used to share a rooming house together in Washington, D.C., because the court didn't actually meet that often during the year, and they went on circuit in those days, the judges, the justices. But when they were in Washington, they all shared one rooming house, and they got on very well together. And which was, if it's raining anywhere, you can drink as long as it's raining. You can drink as long as it's raining. And John Marshall would look out of the window and say, well, I'm sure it's raining somewhere, so we can drink.
That's funny. So yeah, that, you know, that what you were discussing right there about what's called judicial review, that's definitely something I want to get into today. I'm going to save it for a little bit further down the line. Right now, I want to get into a couple of the actual amendments, a few of the amendments, actually. We don't have time to discuss all of them, but let's go through a few of them if we can. I'm going to start with the First Amendment, and I'm going to read it here in your book, chapter 14, page 192. Here's what the First Amendment says. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Now, so this is what is often referred to as the separation of church and state part, but did this mean what most people assume it means? Was there a separation of church and state at the state level?
No, not exactly. And that really has come about through a letter written by Jefferson much later. It's been interpreted in the light of that, which is not part of the Constitution at all. What that amendment really means is there is not going to be a national church as there was in England, and it still is. There is the Church of England, which is still the official state church, state religion of the country. And to this day, you cannot be king of England if you're not a communicating member of the Church of England.
Wow.
And until recently, even if you married someone who wasn't, you had to give up your right to the throne.
Wow.
That was recently changed. But so you can marry somebody who is not Church of England. But that is the established church. There's an established religion. Now, that's the one thing the American founding fathers or drafters wanted to get away from. No established church. No, that's basically what that is saying.
At the national level.
Yeah, of course, it's talking about Congress there, national level. So that's the idea, that not exactly separation of church and state. That was the interpretation put upon it by Thomas Jefferson. But no established religion, no established church.
Okay. But now, is it still the same way now that the First Amendment is incorporated according to the Supreme Court?
Well, yes and no. I think it's now understood to mean that there should be a separation between church and state.
Okay. Even at the state level now.
Oh yes, yes.
Okay.
First Amendment is definitely incorporated.
All right.
The second part of that amendment is, of course, about freedom of speech, and that is very interesting. If you read the wording, read out the wording of that. I haven't got it in front of me here.
Yeah, definitely. It says here, or abridging the freedom of speech or of the press. Now, does this mean all speech, all forms of expression?
Yeah, well, the crucial word there is actually, and that's mostly ignored. Read it again.
Bridging the freedom of speech.
Yes. Why does it say the freedom of speech? What freedom of speech? In other words, that refers to an already existing freedom of speech. Abridging the freedom of speech. In other words, the freedom of speech that was already recognized in Great Britain at the time. That's what it's really talking about.
Oh.
It's not saying there shall be total freedom of speech. It's saying the freedom of speech that exists now, back in 1789, shall not be abridged. That's what it's really saying. People have missed that word. The word "the" is actually crucial.
Wow. That one little word makes a big difference.
Huge difference.
So it's not absolute. You can't, let's say pornography, child pornography, flag burning, any type of obscenities.
Except that the court has reinterpreted all these things. Flag burning, for example, which most people would think is nothing to do with speech, has been interpreted by the Supreme Court as meaning expression. As long as you're expressing your views, you are expressing your views by burning the flag rather than by speaking, so therefore it's okay. Frankly, I think that's a wrong decision, but that is the decision. Most conservative judges have disagreed with that, but not all. In fact, I should say the opposite. Some liberal justices have disagreed with that as well. But John Paul Stevens, for example, who was normally regarded, although he said he was a conservative, normally regarded as a liberal, totally disagreed with that, because he said that's unpatriotic. It's contrary to your loyalty to the country, flag burning. Nothing to do with freedom of speech.
So freedom of the press is also part of that section. So freedom of the press has been challenged many times and has not always come out on top, but for the most part has been more protected than not, I would say. You're right.
Oh,
And you write in the book about the Pentagon Papers, which were top secret documents that were leaked and published by the New York Times, showing the mishandling and failures of the Vietnam War. And the Supreme Court sided in favor of the New York Times for publishing that. Do you think they were right for siding with the New York Times?
oh, it's hard to say on that particular issue. Very, very controversial at the time. But I would say that there is some people sometimes assume that freedom of speech and freedom of the press are one and the same thing. And the press always like to give that impression that their freedom of journalists to write whatever they like, is covered by the freedom of speech. And if you deny them that freedom, you are denying that freedom to yourself as well and to other people. That's not true, I believe. The press has far greater power than ordinary people. And in fact, freedom of the press can actually be used to muzzle the ordinary person, because if you were to write an op-ed, this has happened, I think it was, what's his name, the Republican presidential nominee,
John McCain?
McCain, who wrote an op-ed for the New York Times, which they accepted initially, and then they regretted it because they decided that it didn't agree with their policy. But that is so wrong, because an op-ed, the whole idea of an op-ed is that it should give voice to people who don't always agree with your policy as a newspaper or as a publisher. And yet this was their approach. So usually you find that if a newspaper attacks a prominent person, that'll be on the front page, splashed on the front page. When they apologize to that person 3 months later or 10 years later, that'll be buried on page 33 in a very tiny article. So if at all, I mean, if they do that at all, if they even apologize, but which they very rarely do. But on the other hand, defamation law is much more liberal in America, in the sense that it allows more freedom of speech than in Britain. The British defamation law is so bad that it traditionally favored claimants. If you said someone defamed you, you would have a much better chance of winning. You didn't have to prove that what they said was not true. That was taken for granted. And in fact, that resulted in British defamation judgments not being recognized in America. And that is still the position today, even though British defamation law has changed to make it less plaintiff oriented. Even though that changed, there was a recent law, Defamation Act 2013, which changed that, supposedly, but it still has not satisfied Americans to the point where British defamation judgments are recognized. They're not recognized to this day. And I think that's right in a way, because freedom of speech should be encouraged, and the internet exists, which enables people to speak more freely. But what are the limits? Should there be limits? And of course, the second impeachment trial of President Trump relates to that, and there probably will be further repercussions about that. Was he actually entitled under the First Amendment to make that speech, which resulted in that riot on the, I think it was the 6th of January, 2021, this year? Was that speech inciting to violence, or was it, and is it embargoed by the Constitution or not? And of course, the judgment of the Senate was that he was entitled to. But I mean, obviously, that the vote in the Senate was purely political, purely on party lines. So one can't really judge that. There were 7 in the end, 7 Republicans who voted with the Democrats. But that wasn't enough because they needed a 2/3 majority for that.
So what you said before about the press sometimes blocking free speech, it kind of reminds me a little bit of the conversation that's going on right now about social media and the claim that social media is blocking and censoring conservatives on all of the social media platforms. And they, to a certain extent, deplatformed a more conservative leaning social media app, which is Parler. So a lot of people that I tend to listen to, because I kind of somewhat hang out in the libertarian circles. It's more closer to my political philosophy. So there's kind of a divide within those circles, because the typical libertarian philosophy dictates, hey, they're private businesses, they can do what they want. You don't have to use their platform. Other people can start new platforms. But then there's another faction that says, you know what, I'm sorry, that sounds great, but it doesn't quite meet the challenge here, because the reality is Twitter and Facebook and Google and YouTube, they are the press now to a certain extent, and they are the the public square. So there's even libertarians now that have gone on the bandwagon of, we need to regulate these platforms. What would you say about that?
Well, I think it's a bit dangerous to try and regulate platforms, but censorship certainly should be resisted. And the fact that Facebook, Twitter, and these other platforms are blocking conservative views, I think is certainly wrong. But whether they should be controlled by whom, then that's the ultimate question. Who's going to control them? And I think the internet is broad enough to allow conservatives to have their own platforms. And it seems to be the case that the airwaves, as far as radio is concerned, are, I won't say dominated by conservatives, but there is a very strong conservative presence on radio, but less so on television, and probably less so on the internet, the sort of mainstream internet that you mentioned. But it is a tricky case, and question of hate speech. Is there such a thing as hate speech? And should there be? And should it be illegal? That is a very major question. It's not an easy one at all, but it is becoming, political correctness has crept in so many ways that words, even perfectly innocent words, are now banned. And that applies to even things, well, the word niggardly, for example, was banned a few years back because people assumed it had something to do with the color of a person's skin. It has nothing to do with that, actually, nothing whatsoever. It's not connected etymologically with that at all. But because it sounded like it, and anything similar to that.
And in the UK and in Europe in general, there are a lot of pretty, I would say, extreme. I don't know if you would agree, but extreme hate speech laws. I've heard stories
Oh,
and
yeah.
of people getting arrested because they posted something that was deemed racist or offensive or whatever, discriminatory on Twitter, and a couple hours later they get a knock on their door by the police. Is that true?
Oh, yes. I don't know about Twitter, but but certainly, I mean, I was quite surprised when a firefighter, you're not allowed to say fireman anymore either, because some of them are women. So a firefighter told me that in his fire station in England, this is, you're not allowed to order a black coffee or a white coffee because that is racist.
Wow.
Absolutely nothing to do with race.
Wow.
Of course. It's the
Wow.
color of the coffee.
Jeez.
Whether it's got milk in it or not. What has that got to do with race?
Yeah.
Nothing. But he was up in arms against that. But he said, you've got to be careful. He could lose his job over that.
And the question is, where does this end? So.
Yes, well, that's right. The thought police.
Yeah.
Do have there is a law in England called the Malicious Communications Act, so that you can go to jail for if you make what is considered by the courts to be a malicious communication. What's the definition of that? There's no actual proper definition.
Yeah.
For the courts, and that's the trouble. The courts tend to be very politically correct.
Yeah, no, that's some pretty scary stuff as far as I'm concerned, and from what I understand, it's pretty prevalent in Canada as well. So, but yeah. All right, so let's move along. Another famous case that fits into the First Amendment category is the Christian Baker versus the gay wedding cake.
Oh yeah, well, I've written about that separately. I don't know whether you've seen.
Oh no, I did not. So that's great. I'm glad we're touching on this. Now, when the last edition of the U.S. Constitution for Dummies was published in February of 2018, a decision was not yet made by the Supreme Court. But since then, it has, and they sided in favor of the Christian Baker. So, what's your take on that?
I think that was correct. But in fact, a similar case existed in England, but there the result was different. I think if you are a business, you surely have the right to accept custom or not. And if they want you to write a slogan on a cake, if you're a baker, all right, you don't have to accept every offer. Someone asking you to do a wedding cake, you can refuse it on any grounds. In this case, they particularly didn't want a wedding cake for gay weddings. And what was more to the point was that there was a slogan on the cake which indicated that they were advocating gay marriage. Now, they may say, well, look, we accepted that contract, but purely on the basis that we were carrying out the instructions of our customer. We don't necessarily agree with that. But how is anyone to know that? If the message on the cake says support gay marriage, then it's assumed that the bakers are in tune with that also. And so I can see no reason why they can't refuse it, because you are then being forced. You're then being forced a slogan that you don't agree with. And that's exactly the opposite of free speech. You're actually being denied free speech because you're being forced to speak in a way that you don't agree with. And as far as the customer is concerned, there will be people, and of course there were other bakers who are prepared to bake a cake to those specifications. There will be, and there were. There was an earlier case, which I've written about, and I think it's been forgotten, much, much more trivial case, which actually made that point, and the Chief Justice at the time actually made this point, that this was a case about New Hampshire, where the car, the number plate of the car in New Hampshire normally carries the state motto, which is, what is it? I always rather twisted. Die, what is it?
Live free or die?
Free, die young, I always say.
Okay.
Not live free, die young, but live free or die. And this one person said he refused to put that on his car. He blacked it out. But the state said, no, no, that's not valid, because that is the standard number plate that we have in the state. That's issued by the state. You're not free to diverge from that. But the Supreme Court said you are, because he's, as he put it, he was being forced to utter a slogan that he didn't agree with. It's harmless enough, but he didn't happen to agree with that proposition, and therefore didn't want to be forced to put it on his car. And the Supreme Court agreed. And I think they were right to allow him to not to associate himself with that if he didn't want to.
So
it's forced, that's forced speech, really.
Yeah.
Forced speech.
Yeah, definitely, without a doubt. So the Christian baker again, was that cited on behalf of his religious beliefs, or was it cited on behalf of freedom of speech? Because I thought it was based on freedom of religion.
Well, it is really,
okay.
Yes.
Okay.
The freedom of religion, freedom of speech link up here.
Got it.
But freedom of religion, yes, that in a way you're being forced to renounce your religious views and express views which are contrary to them.
Yeah.
Because these Christian bakers were completely, of course, to them, gay marriage is anathema.
Yeah.
Contrary to the Bible, it's contrary to their religion, it's contrary to God, according to them, and therefore they wouldn't want to be associated with it. But if it's on the cake, they are associating themselves with it. Yes.
And this is a case. Now, I tend to fall on the side of thinking I probably would prefer the Bill of Rights not be incorporated, because I think that just brings the federal government into our lives that much more, even though sometimes for the better. But this is definitely a case where it worked out in this guy's favor, because the entire state was against this guy at every level. And if it wasn't for the Supreme Court, you know, he never would have found what I would call justice. So the fact that the First Amendment is now incorporated actually saved this guy. So,
well, yes and no, because many states have got a similar thing in their constitution anyway.
Yeah.
So that wouldn't necessarily have depended on the federal constitution if it was in the state constitution.
But this particular state, his back was up against the wall from everything I read about it. So,
right. Yeah.
So getting back to the Supreme Court, okay, in chapter 14, you write about a Supreme Court ruling on two different cases involving the display of the 10 Commandments in front of a courthouse.
Oh, yeah.
Now, the first case, it was deemed in violation of the First Amendment, But in the second case, it was deemed permissible. So what's up with that?
Well, they made some minor distinction between the two, as I recall.
What's that?
The one in a park, and the other was in a courtroom, I think. Yes, and there are minor distinctions, but in reality, again, it's about freedom of religion and freedom of speech. And if it's in a courtroom, you could say, well, this is an imposition of these laws from the Bible on people living here today who may not always be bound by them. I mean, certain of the commandments are not, certainly not generally obeyed, like Sabbatarianism. At one time it was much more common. Now, I mean, Orthodox Jews are very, very careful about not working on the Sabbath, all that, and there are some Christians who feel the same way, but the majority of people do not feel bound by that law, for example. Also, even the first commandment about having one God or believing in any God is not something which you can force on people. So the Ten Commandments are a beautiful summary of some of the most basic tenets of humanity. Thou shalt not kill, thou shalt not steal, for example, those, love thy mother and thy father, honor thy mother and thy father. Those are wonderful, but the others cannot be imposed on people willy-nilly. So in a sense, I think you've got to be a bit careful with something like that.
Oh yeah, and definitely. And I agree. I would fall on the side of, you know, if it's disclusionary or offensive or whatever, like why are we even doing it, you know? So my point wasn't so much in defense of having the Ten Commandments on display at a courthouse. My thing was just more like, you know, in one case they deemed for it, in the next case they deemed against it. It just seemed kind of arbitrary.
I'm not sure I think it's in my book, but I'm not sure exactly what the distinction was that they drew. They did make some minor distinction, but I think that was more of a distinction without a difference, as it were.
Okay, so there was more to the story then.
I would say in a courthouse it is more dubious, because it's not really part of the law of this country. Whereas if it's displayed in a park outside somewhere, I can see no reason why that should not be the case. Because it's part, on the other hand, while it's not part of the law of the United States, it is part of the general tradition of the Abrahamic religions, of the Judeo-Christian ethic, and is accepted in that respect by Jews, Christians, and Muslims. But not everyone is a Jew, a Christian, or a Muslim. You don't have to belong to any religion. And you may be offended by something which says thou shalt have only one God. You may not have any God, or you may have lots of gods.
Sure. No, I agree with that 100%. Now, in chapter 2, you quote Thomas Jefferson as saying, the Constitution on this hypothesis is a mere thing of wax in the hands of the judiciary.
Yeah, well, that's part of his attack on John Marshall. It's really a reaction. That really is a reaction to the Marbury versus Madison case, which really rankled him very badly. But he never had the guts to take action against Marshall, strangely.
And in chapter 2, you also quote
He's right. That is what has happened. The law has become a thing of wax in the hands of the Supreme Court, and we've seen that just lately, particularly in the last 20, 30 years, particularly.
So, and also in chapter 2, you quote Justice Charles Evans Hughes as saying, we are we are under a constitution, but the constitution is what the judge says it is. So what did they mean?
But he went further and said, and the judges protect our property and lives and so on. He actually was in favor. So that quotation is usually taken out of context.
Oh, okay.
I think I put the full quotation there to indicate that he actually was in favor of it, because he became Chief Justice. He didn't say that at the time. Well, this was much earlier, but he later became Chief Justice. So, of course, he agreed, actually, that the court should have that kind of power. It's not an attack on the court's power. It's a description of it, but he actually agreed with it.
Yeah.
But it's true. It is true, unfortunately, because the court was never intended to have that power, as Thomas Jefferson always insisted. And I would go with Thomas Jefferson on this rather than John Marshall.
So can you explain that a little further? What is the problem with the court having that power of judicial review?
The first problem is they're not elected. The second problem is that they're there for life, and therefore they can be they can be dictators. And the fourth problem, is that they don't agree. That there's no agreed basis of constitutional interpretation, so that you have someone like Antonin Scalia, who was an originalist, who would take the words of the Constitution as they were written there and take them very literally for the most part. And then on the other hand, you have Ruth Bader Ginsburg, or one of the other liberals, who would say, no, the Constitution is a living document, the living Constitution, and therefore we have to interpret it in accordance with society as it is today. Just because they didn't have any conception of gay marriage in 1789 doesn't mean that we can't have it now. Any conception even of privacy. There is no right to privacy in the Constitution. That has been created by the Supreme Court. The right of abortion is another of these rights. Certainly doesn't exist there. Now there, actually, Ruth Bader Ginsburg had an interesting take, because she said that she thought that it was very heavy-handed of the court in Roe versus Wade to wade, make a bad pun, to wade into this question, because she thought this was really a question for the electorate to decide. And she said she felt that at that time, which was 1973, the feeling in the country at large was moving towards abortion rights, and should have been left to the state legislatures to legislate on. But for the court to make law in that way, which was very heavy-handed, she was actually against. She was in favor of the principle, very much in favor of the right of women to have abortions in those circumstances, but she was not in favor of it being done by the Supreme Court, surprisingly. Most people don't know that.
Yeah, I read that in your book, and it also said that she thought that it just caused more conflict.
Well, rancor.
Yeah.
Because in Britain, for example, that's one of the areas where British law has actually proved superior, because there it came about as a result of an act of Parliament, which became law as a result of the very, very incessant hard work of one backbench member of Parliament who kept bringing it forward, and it became law. And once it became law through Parliament, there was very little dissension. There has been very little argument about it since then, very little. Very few cases have ever come before the courts. in regard to abortion. Very few. I think because of that, it's got the democratic stamp of approval with it on it, which I think is correct. But for a court to make law in such a blatant fashion on something so important, and something which really isn't part of the Constitution and shouldn't be, I think it's completely wrong. And also, I think it's a wrong interpretation of the law, because why is it that that is regarded as being a woman's right entirely, maybe with her doctor, but not her husband? The father has absolutely no rights. There was an attempt at one time to bring that in America, and to say that the husband must have some rights as well, but that was completely defeated by the Supreme Court. The husband has no right whatsoever, or the father. And I think that's wrong, because to regard an abortion, question of abortion, as being part of a woman's body, I think is in itself a mistake. Whether or not you regard fetuses as having any rights of their own, that's a separate question. The unborn child, whether you regard that as murder, I mean, that's something else perhaps. But I think it's a basic thing whether the father should have rights.
Yeah, no, I can relate to all of that. I have my feelings on abortion as well. I would probably side closer to the pro-life side.
Yeah.
But what we're discussing is, how did this law come about? And I agree with you, and Ruth Bader Ginsburg agreed with you that it probably wasn't the best way to put it into place.
Well, it was used as an extension,
yeah,
from privacy, which in itself isn't there.
And all of these supposed rights that aren't actually in the Constitution, for the most part, come about through the Supreme Court. Is that right?
Yes, they have.
Okay.
They have.
Okay.
Of course, the woman who brought the Wade versus Roe later turned against it and said that actually she wasn't pregnant, and she'd been pressured into bringing it to court.
Yeah. Yeah. So I want to move right along, because we are running way over. But I got at least a couple more things I want to try and get through if we can. Let's move on to the Second Amendment. Okay. So there's no shortage of controversy and confusion surrounding this little amendment. What's the deal with it?
That's one of the examples one could give of where the Constitution is not clear. The language, partly old-fashioned language and partly just the drafting, because was it meant to apply only to a well-regulated militia? That's what it says. Or was that just like a throwaway clause, and it actually is a right for all citizens? Well, now it's been interpreted as meaning it is a right for all citizens. But in fact, there are restrictions on it which are still allowed. There are states where there are laws that do restrict the type of gun you're allowed to own, and in what circumstances you're allowed to carry it, and so on. And I think that's probably correct. I mean, like Washington, D.C., which was not a state, they have quite stringent laws. And other states, very, very few, if any. So whether it was originally intended to apply to everybody, not clear at all from the wording. Scalia thought that was the intention. Stevens, who actually also, I mean, he was, on this point, he was a liberal, in other words, against the right. He went through the history of it as well and came to an absolutely opposite conclusion. But in Britain, there's never been a total right to possess arms for the ordinary citizen. You have to get a license.
But even Scalia, who was the leader of the individual rights school of thought of his time, even he said that the right to bear arms is not unlimited.
No, exactly. And I think that's correct. I think there should be some restrictions. I mean, should you be able to carry a cannon around with you? Probably not.
So
yes.
Is the part about shall not be infringed also not exactly what it sounds like?
Well, yes and no, because infringe what? It depends what right you're talking about being infringed. You don't know where you're starting from. Are you starting from a position where this is a right attached to a militia, which is really, I suppose, the National Guard? People today would equate that to the National Guard of today. So that if you're in the National Guard, yes, then you have a right to possess a firearm, which you can keep at home, like in Switzerland. In fact, you have to. In Switzerland, all males are called up to the army, 2 years service, compulsory military service, and they have to have a rifle at home, in readiness. They have to. But that's all tied to military service. Is that the case in America? In which case, it would be to do with the National Guard. Or, as is now the view, the law, does it apply generally? It's nothing to do with the National Guard. So, infringe what? That's the trouble. Like with the First Amendment, the word the, infringe the.
Yeah.
Abridge the right that already exists. You've got to know what already existed.
Mm-hmm.
So I think what's come out of the Supreme Court over the Second Amendment is probably correct, with that caveat of Scalia's that there've got to be some limits. There've got to be some limits. Okay. And but of course, there's also this problem of who to blame, because, of course, those against Second Amendment rights say this is all the fault of the NRA and of those who make money out of selling firearms, and it's contrary to the ordinary citizen, and it's caused a lot of murders. And of course, on the other side, it said, well, no, guns don't kill people, only people kill people. And what surprises me is that there are no proper precautions taken. The most obvious thing is to have a metal detector in every school at the entrance. It's not an expensive thing. You're not paying retired police officers to come on duty, and you're not training school teachers to become security officers, which is something else people have been talking about, which I think is ridiculous. You'd have a metal detector in every school. I can't understand why that isn't done. When you go to an airport, when you go to a public building, you expect to be frisked, or not necessarily frisked, but you expect to have to go through a metal detector and to have some security precautions. Whereas in most schools, universities and ordinary other public buildings are not exactly belonging to the government, there's nothing like that. Now, why? It's an obvious thing. Even shops maybe should have that. But it's not, that's not a great imposition on freedom, and that will cut down this murder rate tremendously, tremendously. You don't need elaborate precautions where people are talking, oh, you've got to train up a lot of teachers. Hopeless. No teacher wants to be a security guard. That's not their job. Or we've got to bring in a lot of police officers or retired police officers. Nonsense. You may need one operator standing by by the machine. That's all. And make sure you have as few entrances and exits from any building as possible. I can't see anything wrong with that. I mean, there was a case with a synagogue recently where a man, the perpetrator, as it turned out, tried one synagogue. He realized that synagogue was all locked, secure. He went on to the next one, which was all open. Then he killed a number of people there, of course. It was an open invitation. Did they have a security guard? Yes, inside the synagogue. That's hopeless. He didn't attack the previous synagogue because that was locked. The second one had no proper security. It was an open invitation. So I don't blame them exactly, but they should think about these things. And you can't say, oh, it's all the, if only people were deprived of gun rights. That wouldn't help either. Criminals, and this is something, of course, that the gun rights lobby always says, criminals always have guns. You can't stop criminals from having guns.
And it seems to be, I don't know if it's a coincidence or not, but it seems to be that a lot of these mass shootings always seem to happen in places where guns are not allowed.
Yeah, well, of course, because the perpetrators don't want to be shot themselves.
Yeah.
Although sometimes they do shoot themselves. But yes, of course it is that way. But it's not properly controlled, like in the cinema in Colorado. That was also a gun-free zone. What good did that do?
Yeah. I just recently moved here to South Dakota from New Jersey. So New Jersey is a highly regulated state when it comes to owning a gun. And South Dakota, pretty much everyone owns a gun and carries with them all the time. I work in an office where every single person in the office is packing all day long. And
I don't think there have been that many murders or mass murders in South Dakota.
I don't think so. Yeah. Because I think it's pretty well known that pretty much everyone here carries. So I think that has a lot to do with, that doesn't mean that there aren't armed robberies. There isn't crime that does happen, but I don't see too many like mass murders, you know, because they know they're going out in a matter of minutes.
Yeah, well, exactly. Yes.
So, so let's move along. You mentioned before the 9th and 10th Amendment. Real quick, to me, when I read these two amendments, they almost sound like they're saying almost the same thing, or they seem to be very similar.
Yes, they are. Basically, the 9th is saying the rights enumerated here are not all the rights. Do you have a right to pick your nose on the street? Yes, unless there is some local bylaw which prevents that, and sometimes there is. You can, and the same applies to rights. Prohibitions and rights, unless just because this is a constitution doesn't mean this is all the rights you have. And I think that's very important to realize. It doesn't incorporate all the rights, and that's the 9th Amendment. The 10th Amendment is saying the rights here are only to do with the federal government. Anything else, and there are plenty of other rights, those belong to the states or the people. Anything which is not given to the federal government still belongs to the states and the people.
Okay.
And I think that's very important to stress.
But just to be clear, they can still make a law anytime they want with any of these unnamed rights. So
yeah, the feds or the
states or local municipalities. It's not that just because they're not named doesn't mean they're guaranteed. They're not necessarily guaranteed forever, because somebody could write a law at any given point.
No, but the 10th Amendment is saying the rights enumerated here belong to the federal government, but there are other rights floating around. Those belong to the states and the people, and it's up to them. It's up to them. Yes, in some states there are more rights than others. In some states you may have to show ID. photo ID to vote. In others, you may not have to show any kind of ID to vote, and so on. So that's up to the states. So again, that's all part of the federal structure, and I think it's correct that it should be, and I think it's correct to stress that, to realize that the federal constitution is just that. It's a federal constitution. It's not a code of laws for everything you do in your life.
But then through the Supreme Court, with the 14th Amendment used as somewhat of a justification, some parts of the Constitution, namely the first 8 of the Bill of Rights, didn't used to apply to the states, but now they do.
Yes, now they do.
Okay.
And but as I said, some of them already applied as a result of individual
Got it.
Individual constitution, state constitution.
Got it. I don't know. To me, that's just so confusing, you know. But that's why we have your book to help us figure this out. So let's move on to the 14th Amendment. The 14th Amendment really covers a lot of stuff. I'm reading from your book here: the definition of citizenship, the obligation of the states to uphold privileges and immunities, blah, 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 due process, obligations of state not to deny equal protection, and a whole bunch of other things.
Yeah, one of the things there that's very controversial is whether that amendment actually confers the right to anyone born in the country to be an American citizen. Just to, you know, you're on a tourist visa and you have a baby in America, does that baby automatically become an American citizen? And of course, you have people who do this deliberately, who come to America specifically to have their baby, so that the baby will have American citizenship.
Mm-hmm.
Should that be allowed? Well, according to the U.S. Constitution, or to the U.S. Supreme Court at the moment, that is the position. But whether it should be, whether that's the correct interpretation, I don't know. That amendment is a bit vague, unfortunately. As I say, the 14th, 15th Amendments were drafted by the Little League drafters.
Got it.
Not the same league. They've copied bits from the 5th Amendment. They've copied bits.
Okay. Now, in the 14th Amendment, the part that says no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. And then it goes on and on. So is that the key part that is used to back up the argument that the certain portions of the Bill of Rights applies to the states?
Well, yes, it was used that way. It was used that way.
Do you think that's accurate, or you think that's just the way they interpreted it?
I think it's accurate to some extent, because certainly the 14th Amendment is geared to the states. That's why it says there's no state. It's actually directed, it's addressed to the states, unlike the original Bill of Rights, which is not. The original Bill of Rights is addressed to the federal government.
Okay.
So insofar as that is addressed to the states, I think that may be correct. On the other hand, I think I may have written about this in the book. At the time, one of the drafters of the 14th Amendment was actually trying to pass a separate law in Congress that made the First Amendment applicable to all states. So he didn't seem to think the First Amendment already applied to the states, because he was bringing in a separate law for that, a separate amendment. He wanted to actually bring in a separate amendment that made the states recognize the First Amendment. Well, if he thought that and he was one of the drafters of the 14th Amendment, means he didn't think the 14th Amendment included that. But the Supreme Court subsequently felt that it did.
Yeah.
I don't think there's any way of going back on it anyhow. I think
at this point, right? So
done piecemeal.
Yeah.
Bits and pieces here and there, but now we're at a stage where, as I say, except for those two little exceptions in the Fifth Amendment, the whole of the first 8 now are applicable to the states as well as to the federal.
Okay. So this is the last question I'm going to ask about the dynamic between the federal government and the states. I know I've kind of dwelled on that a little bit, but it's kind of, for me, it's just like an ongoing conversation that I have with people on Facebook. So I tend to prefer the Constitution having as little bearing as the states as possible. Do you think the incorporated Bill of Rights is actually better for individual liberty, states' rights, and small government, or worse?
Well, I think because of the very broad way in which those rights are now interpreted, it probably isn't so good. On the other hand, it would be a mess if you had, say, for example, abortion rights recognized in one state and not in another state. That would make a mess. And it was the case before Wade versus Roe. There were 46 states which had laws prohibiting abortion. All those 46 state laws were declared unconstitutional by the Supreme Court in Wade versus Roe. 46 of the 50 states. Now, there have been attempts by some states to introduce, as it were, by the back door, some restrictions on abortion rights, without entirely reversing Wade versus Roe. And with a greater number of conservative justices on the court, there is speculation that some of those states do prevail, but so far they haven't. But there are now more conservatives on the court than ever, well, not for a long time anyway, because, of course, of the 3 Trump nominees. This is probably the most lasting of Trump's legacies, is his 3 nominees to the US Supreme Court, which was quite a coup for him. I don't think Ruth Bader Ginsburg was planning on giving Trump the right to choose her successor. Mm-hmm. She was planning on retiring at the age of 90, like John Paul Stevens, but it didn't quite work out for her. She would very much have liked to stand down when there was a Democratic president in the White House, but that wasn't a choice given to her.
Sure.
And so as a result of that, there are now 3 conservative justices, plus the 2 who were already there, Clarence Thomas, of course, and Alito, which is a majority. 3 plus 2 is 5 out of 9. And John Roberts used to be thought of as a conservative. Now I would say he is more of a swing vote, and he has been siding with the Liberals on quite a few occasions. I think he likes the idea of unanimity, which is very rare. Actually, it's not as rare as people think, because on a lot of unimportant cases, or cases that don't affect a lot of people, there is unanimity, actually. So that's wrong in a way. But on these very, very contentious matters, there isn't. And of course, there is the proposal by some Democrats to pack the Supreme Court. In other words, to enlarge the number of Supreme Court justices. And is that something that they could do? The answer is yes. The Constitution does not specify how many justices there should be.
And that almost happened under FDR, right?
I wouldn't say it almost happened. He wanted it to happen because a lot of his legislation, New Deal legislation, was being struck down by the Supreme Court, 5-4 decisions, as unconstitutional. And he got livid about that, saying that these people cannot impose their economic people, because he had a massive majority in Congress and as president. So he said, as he put it to the country in one of his radio addresses, fireside chats as they were called, the government is made up of three. It's like three horses pulling the government. Two of the horses are pulling together, and one isn't. And that one is the Supreme Court. And this can't be allowed to continue. And he had a plan whereby once a justice turned 70 and a half, I don't quite know why there was the half, he as president would have the right to nominate an extra one. There was no limit on the number. Of course, that would have resulted in a majority for him. But as it turned out, it wasn't necessary, because a different Roberts, not John Roberts, but another Roberts who was on the court at the time, switched sides. And the phrase was created by the press, a switch in time saved 9.
Yeah.
The 9 justices.
So it was more of a threat than anything.
Well, he would have gone through with it had it not been for the fact that Roberts switched sides.
Yeah.
Owen Roberts. But there's a bit of debate about whether he was planning to, whether FDR knew about it beforehand, whatever. But in fact, Congress threw it out. Congress, even though he had a huge majority in Congress, he was not supported by Congress, and his own vice president was against it, Garner. Not that matters much.
The imperial president, as they called him.
Yeah. Well, it's 1869. The number on the Supreme Court has been 9. But prior to that, it did fluctuate a lot. Initially, it was 6, then it became 5, then it became 6 again, became 7.
Mm-hmm.
But only since 1869, well, I mean, that's a long time ago, obviously, but since 1869, it's been 9. Obviously, got to be an odd number, otherwise you're going to have a tie a lot of times, which you don't want.
And
but,
they were accusing Biden of having plans to pack the court once he became president, and he never really. I don't think he ever came out and actually said one way or the other.
I don't know if he did, but certainly some of his supporters have done. I think because they were stung by the fact that there were these 3 extra conservative justices. I mean, what is particularly sad, though, in a way, is that there are these 2 very, very diametrically opposed interpretations of the Constitution. Because for the most part, the rest of the law in America is not like that. In state courts around the country and so on, there's no big difference of opinion on the law, unlike in Britain where there is, because there's no codification, and it's actually in a very terrible state. And I've written about that in the book called Anglo-American Law, a comparison. You have cases all the time with politics where there are complete differences of opinion on what the law is. And it really makes for a real dent in justice. You can't have justice where there's constant disagreement amongst the judges and there's no understanding of what the law actually is. In America, that's not the case, except at the very highest level, unfortunately, in the Constitution.
Yeah.
You know, but who's going to say anything else? The Chief Justice hasn't the authority to say, now look here, from now on, this is the interpretation. He hasn't got that authority. Nobody has. Nobody has.
And if we were to have some type of a constitutional convention to like rewrite the Constitution, that would probably wind up, we'd wind up in a worse situation, most
That
likely.
wouldn't be any different, because that's always, any constitution is always going to be open to interpretation.
Yeah, that's true. So we're nearing the end of the tunnel, I promise, but I want to continue a little bit more with what we're doing right now, which is stuff that's a little bit more topical and in the news. So in light of the events of 2020, especially the Black Lives Matter riots and the COVID situation, so in what circumstances can the president declare a state of emergency? Should Trump have declared a state of emergency? What should he have done? And what would the state of emergency allow him to do?
Well, there is an act of Congress on this, actually, although there are a number of powers, which I suppose you could call emergency powers, already embedded in the Constitution. But there's the National Emergencies Act, 1976, which was passed, strangely enough, during the presidency of Gerald Ford. It has got certain restrictions on it, and the president has to come to Congress and so on. It hasn't been used very much. But I think he really should have, and something I did advise him to do on the internet. I think he really should have. He was a little bit too, if you like, states' rights over that by throwing the ball into the court of the state's governors and then criticizing them, for which I don't think he got any thanks from the electorate.
No.
I do think that called for a national emergency. I don't see why that would have been resisted. I mean, it might have been resisted, but I don't think it would have been successfully resisted.
But that was the main complaint from the Democrats, was that he wasn't taking control of the situation. Am I
Well,
wrong?
yes, that was their complaint, because he wasn't. If he had, their complaint would have been that he was too control.
Yeah. Yeah.
You know, I mean, that's playing politics. You always got to play politics, obviously. But no, I think he was wrong not to do that. I think he was wrong.
And
Just
what
to allow cities to burn like that, one after the other. I mean, the country was in a state of chaos.
Yeah.
And especially when you got what he called the fake news onto it, they would only show you the worst possible scenes and then blame it on him. But he could have cracked down on those and he did say on occasion, this has got to end and this will end right now, but it didn't.
Okay, so we're specifically talking about the Black Lives Matter riots and protests right now.
Yeah.
Okay, all right, got it.
But any kind of riot, I mean, of course, then there's the other riot he supposedly sparked off in the Capitol in January by giving that speech, inflammatory speech, supposedly, and using the phrase, we will be going to the Capitol, something like that.
Yeah.
Gave the impression that he was going to be leading them to the Capitol, although not necessarily in a frenzy of attack. I don't know.
Yeah.
But
to his defense, he did say we're going to go there peacefully and let our voice be heard. But I think in hindsight, he really should have maybe thought twice. I don't think he
Well,
knew who supports him,
uh,
actually I shouldn't say that. It's a pretty bad blanket statement. But when I say that, I mean some of the more fringe people who do support him, which every political party, every candidate has their fringe people, not just Trump, but some of these people, they were really ready for a fight. And I don't think he gauged that well enough. He was too caught up in the moment, I would say.
well, and I think they were particularly incensed by what they saw as a stolen election.
Yeah.
Whether there was any truth to that, I don't know. That's still coming up before the Supreme Court, although it makes no sense. It's moot, because they're not going to reverse. They've already said they're not going to reverse the result of the election. But that will look, if they come out with a conclusion that the election was actually, there was fraudulent, there were fraudulent votes. But I have a feeling they will make sure that even if they say that, they'll be sure to add that, but it would have made no difference to the result. There may have been some fraudulent votes, but not enough to change the result, because you would have needed a lot. And that's where I would say that's something I've written about. It's not in the book. How to solve that problem. People blame the Electoral College and say, oh, this Electoral College system is so antiquated, it's causing all these problems. Well, it isn't causing the problems. What's causing the problems is something else, which happens to be linked to the Electoral College, but is very different from the Electoral College, because the Electoral College is in the Constitution. You can't abolish the Electoral College without a constitutional amendment. But this other thing isn't in the Constitution, and that is winner take all. The winner take all rule, where in, like, California, you just need to beat the next highest candidate by one vote. In talking about presidential election, if you get one more vote than the next highest candidate, you take all 55 electoral votes. That's complete nonsense. And there's no need for that, and it's not in the Constitution. Why can't it be split proportionally, so that if you get 40% of the votes in a particular state, you should get 40% of the electoral vote for that state? That happens already in 2 states in not quite as straightforward a manner as that. That is Maine and Nebraska. They're not quite as straightforward. There's a bit of a mixed system there, but those are very tiny states. So splitting the vote there isn't going to make any difference to the overall result normally. It has on occasion been split. This last time it was, but it didn't make any difference to the overall result. Whereas if it were across the board, it would. I think it could make a very big difference. And I think then the popular vote and the electoral vote would not normally be different, because that's one of the things that rankles people. How can somebody is 3 million, or in this case perhaps even 7 million votes short, lower than the other person, win the election? In the case of the 2016 election, the candidate with 3 million less popular votes won the election. In 2020, the one with the most popular votes won the election, which may seem fairer, but assuming, of course, that those votes were cast fairly. But this would obviate the need for all this business about fraudulent voting, because the difference between winning by 10 votes and winning by 1 million votes, would no longer, there wouldn't be the need to make sure that you win by just a few votes. But that's all you need now. You just need to be ahead by a few votes. In the end, in the 2000 election, Bush was declared by the US Supreme Court to have won, I think, by 537 votes in Florida. That's what carried the whole election. 537 votes in Florida. That's wrong. An election shouldn't hinge on such a minor thing as that.
And I know this is kind of a side note. This doesn't really pertain to what the point you're trying to make. But as far as changing the winner-take-all system, it could have another effect, I think, where it actually could encourage more people to vote. And because there's so many people like in solidly blue districts that don't even bother because they know it's not going red. But
they assume their state is either red or blue, and they don't bother.
We could see a literal shift in the voting dynamic, demographics throughout the country based on that, I would imagine.
Oh, I think that's right, and I think that's another good point in favor of it.
Yeah.
Whether that could ever be agreed generally, I doubt, but it won't require a constitutional amendment because it's not in the Constitution, nothing to do with the Constitution.
Got it.
It's up to the individual states. That's how Nebraska and Maine managed to do it, and they could change back.
Yeah.
And there are other schemes which are not as good, but that scheme, it's a very simple scheme. Split the electoral vote in accordance, in proportion to the popular vote in each state.
Can you think of any reason, because there's always some angle, can you think of any reason why they don't currently do that, or is it just an accident of history?
Well, I think because it's not politically in their favor. I mean, for example, I don't think the Democrats would like to share the vote in California or New York,
sure,
which will normally go blue, but may have a sizable red contingent.
Sure.
So just because you're sure you're going to win California and get all 55 votes there, if it changed to what I'm suggesting, you might lose 20 of those votes, 30 of those votes. You still win it, but not in the way that they have been used to.
And the truth may be the same on the other side. There may be some red states that don't want to lose those votes either. Yeah. That's right. No, makes sense. Makes sense. So I want to continue with one more thing that's recent, topical, in the news, and it's connected to the election and all that. So and also connected to what you were saying about the January 6th insurrection, quote unquote. So in light of what happened recently with Trump and the impeachment, there's no way I could end this interview without asking you about it. So is it constitutional? Is it constitutionally correct for an ex-president to be impeached?
Yeah, well, I don't think so, really, on the basis of, again, the wording of the Constitution, because the only thing that impeachment seems to be for is removal from office. If you're not in office anymore, then it should no longer be applicable to you. However, there has been one case which seems to contradict that, and that's the case of Belknap, William Belknap, who was Secretary of War under President Grant, and he was involved in quite a lot of corruption. And in 1879, Congress was moving to impeach him, And he quickly ran over to the White House, burst into tears, and resigned. And they then went ahead, nevertheless, with the impeachment, which they had already begun. And that's why he resigned. And they said, well, he's only resigned to avoid impeachment. We can't let him get away with it. And it went to trial before the Senate. And I think they took at least 2 weeks to discuss this question of whether he could, in fact, be impeached, having resigned. And he was acquitted because they weren't able to get the 2/3 majority. And of the 25 votes that he got in the Senate, which, because the Senate was a lot smaller back then, 23 of those made it clear that the reason they voted in favor of him was not because they didn't think he was guilty of the offenses that were charged, high crimes and misdemeanors, not anything to do with that, but simply because they didn't think it was right to try him as an ex-secretary, ex-cabinet secretary. They made it clear. 23 of the 25 who came out in his favor made that clear, that was the reason. That was the only reason.
And do you believe that that was correct?
I think probably, because in his case it was also immediate, I frankly think that impeachment is not intended except for removal from office. And they were talking this time around in the second impeachment of Trump about, yes, but what about banning from future office?
Yeah, which is what they're really doing.
And there. He can be removed from office and banned from holding any future office under the United States. But I think that and shows you how these words, the and can make such a difference.
I was just thinking the same thing.
I think the word and there means that's riding on top of the removal from office. I don't think it's separate. It's not or. It's not or. It's and.
Got it.
So I think you have to be removed. It's only for removal from office. Yes, and other things can ride on top of that, but not separate. Permanent banning is not an or. So I think that's wrong. I think someone or lost the election, who's no longer in office for one reason or another, should not be able to be impeached. There are the ordinary law courts for that. You know, the crimes that impeachment is supposed to cover are what are called high crimes and misdemeanors. And of course, that's been endlessly debated as well, what is meant by that. But that aside, something like inciting an insurrection, which is more or less what he was accused of, could certainly be brought in the ordinary law courts. And I have a feeling will be now. I think.
Really?
Oh yes, I'm quite sure he will be. He will be indicted on that in the ordinary law courts, which is where it should have gone in the first place. I don't think it has anything to do with impeachment at all, because it's a judicial function. It's a judicial. Trying someone for high crimes and misdemeanors normally would go to the judiciary. It only goes to the Congress because it's to do with office holders.
I think their main motivation of trying this, whether it was right or wrong, was, like you said, to just prevent him from running again.
Well, of course, but they should have realized they didn't have the votes because they needed 2/3.
Yeah, mathematically speaking, it was a given that it wasn't going to work.
Yeah,
so.
I mean, there were 7. I thought originally 6, but then there were 7 Republicans who defected to the Democrat side. But they should have realized that there weren't going to be many more than that. It was never going to be a majority.
Yeah.
Never going to give them a 2/3 majority. They should have realized that. They could have done the math and realized that from the beginning. But somehow either they didn't or they did, and they didn't care. But and of course it rankles, gives a bad taste in the mouth. Here's the only president who's been impeached twice. And of course, unfortunately, people don't understand the word impeached doesn't mean found guilty of anything. Impeached just means that you've been accused.
Yeah.
You've been accused and brought to trial on this. But it doesn't have the meaning of actually being found guilty. That's separate. So that, for example, all the presidents, in fact, who've been impeached have been found not guilty. Not one of them has ever been found guilty.
Yeah.
But there have been now 3 presidents impeached.
Okay.
Didn't do Clinton any harm.
No.
And Trump, I don't know. So they can't block him from running for office, except, I mean, he'd be 80 years old. So, frankly, I don't think he's really in the running.
I don't think he's going to run. But I would imagine his family is, though. But we shall see.
I think he's going to be a major contender on the internet and on the television.
Yeah.
He had a very successful show on television for years, The Apprentice show. Now he can have a sort of lambasting of the Democratic administration.
He also still has an unbelievably huge, or should I say huge in Trump speak, following. He has a huge following. So he can also be a kingmaker. You know, just by his endorsement, he could get people voted into office.
Well, and he's already done that, and he's already blocked some Republicans from being re-elected or from running again.
Yeah.
Yes, and that probably will continue.
So we could go on all day, but I definitely want to bring this eventually to an end, for your sake more than mine, because trust me, I could do this all day. But I know, every good thing needs to come to an end. There is one last thing, though, and we'll make this as quick as we can. Okay, so I posted on Facebook that I was going to be interviewing you, and I had several people post questions. Now, just for the sake that they were nice enough to post the questions, I just wanted to run it past you real quick, and then we can wrap it up. So the first question was submitted by a guy I know named Eric. Now I can't really sum up these people in like a word or two, but just because I feel like doing it, because it's more fun, I'm going to. So we're gonna call Eric the Angry Republican, okay? And his question is,
okay, not Eric Trump then?
Eric who?
Eric Trump?
No, not Eric Trump. No, my friends aren't that high level yet. We'll see. So his question is, why is it that the Second Amendment seems to be unique in the fact that there are so many laws regulating and restricting gun ownership, as opposed to slavery or women's suffrage, which have no exceptions?
Well, I think there's a bit of a difference there. And although I agree that there should be a right of gun ownership, I also think with Scalia that there's got to be a limit. Should you be allowed to carry a cannon around with you? With voting rights, you either have the right or you don't have the right. But with gun rights, it's not as simple as that, because it depends in what circumstances should it be hidden or open, and what type of firearm should you be allowed. So I think it's not a parallel. It's not a parallel. I think it is fair, but there should be some restrictions.
I think that was a great answer. I don't think Eric is going to like your answer, but I'll back you up. Okay. So now the next question was submitted by Hector, and we're going to call Hector an angry libertarian. Okay. So was the Constitution intended to rein in the growth of the state? If so, does it have any self-correcting processes that automatically kicks in to assure this, or does it not have any such mechanism? And so are we left to conclude that the Constitution is structurally designed to encourage the growth of state? And again, remember, I said angry libertarian.
To encourage the growth of the state, or to encourage the growth of the Fed?
The growth of, well, when he says state, I believe he's not talking about states like states' rights, like New Jersey, Massachusetts.
Right.
He's using that word to mean basically government.
The government, of the federal government.
Yeah.
Well, certainly the original Constitution, the Confederation, was very loose and gave total power really to the states, and there was no executive. So that had to be brought in. So to that extent, by having an executive straight away and a more unified government, albeit federal rather than just a unitary state, it's federal, but it did rein in the states to some extent. And after the Civil War, much more so. And that was deliberate. And also the rise of the imperial presidency has had that effect since FDR, Truman even, and certainly later Kennedy, Nixon, Johnson, the president, Reagan even, the power of the presidency has grown. And of course, as the power of the country has grown, so the power of the executive has grown. So, I mean, the leaders of China and Russia couldn't understand how the president, Richard Nixon, could have been treated in the way he was and forced out. That could never happen in their country. Well, yes, I mean, it could in a way. They've had, assassinations and whatnot, and all sorts of shenanigans. But once someone is ensconced in power, they're there for good, like Putin in Russia now and Xi in China. These people are practically irremovable. They can't understand it. And the same applied then, Mao and the Russian leaders. To them, Nixon was a great statesman. He was in many ways. And how he could have been treated so shabbily by his own country, they couldn't understand. They still honored him the same way as they had when he was president. And so the fact of America's being a great power, which really only happened, you can say, after World War I, has enhanced the power of the president, particularly. Woodrow Wilson didn't quite manage that, because although he had a big liberal plan for the rest of the world, he wasn't a big liberal at home. In fact, he segregated Washington and was insistent on segregating the army, and even gave a speech telling black people in Washington, D.C., how good it was for them. Segregation was good for the blacks.
Well, I would argue that back then, progressivism and racism and even eugenics was very intermingled.
Oh, yeah, yeah. But he was a great statesman on the world stage, although he wasn't able to persuade America to join the League of Nations ever. It was his invention, but America never joined. But then, with the Second World War, World War II, again, FDR said he wasn't going to go to war, just as Wilson had done. He had to in the end because of the Japanese attack on Pearl Harbor. Some say he knew about it in advance, he wanted that, and so on, I don't know. But the point is, that is what really put America on the map. But when America is on the map, that means the president is on the map. It greatly enhances the executive. Yes, they're supposed to be controlled by Congress over war, declarations of war, which have never been made since World War II, are supposed to be under the control of Congress.
Which is something that I desperately want to talk about, but we're not going to have time today to get too deep into that. But finish your thought.
Foreign policy is the one main area where the power of the presidency has greatly increased because of the power of the country, and also partly because of policies sometimes rather recklessly pursued by the president, like, I mean, the Vietnam War, which was a complete mistake from the beginning, I believe.
Oh my goodness, don't get me started.
And Lyndon Johnson had no clue about foreign policy at all. He didn't have a clue. Nixon was then plunged into it. He was much better on foreign policy, but he also resorted to expanding the war. But I rather feel that that was because he felt he was pushed into it. I don't believe he really wanted that. Whether there would ever have been a Vietnam War had Nixon won in 1960 instead of Kennedy is something I've often pondered. And I really wonder, because Nixon was not a warmonger, and Republican presidents generally haven't been, which is the interesting thing. Reagan made peace with the Soviet Union, and Trump, of the most recent presidents, he's one who did not declare any new wars.
Yep.
I mean, George Bush, those two wars that he opened up, completely disastrous.
Yes.
And totally unnecessary. Totally unnecessary.
And we're still there.
Still there, absolutely. So, but that's really what's made the president more powerful than Congress. Although in the 1870s, a political science student or graduate wrote a book called Congressional Government, in which he said that the way he portrayed American government was Congress controlling it. And who was that student? Woodrow Wilson, who became a very strong president, except when his wife was the president, of course. It was towards the end of his life when he had a stroke. She actually ran the country. Pretended it was him. But doesn't mean he wasn't a strong president. It just means it wasn't him. It was his wife. And I think that's all come out lately. But at the time, I don't even think his cabinet realized. They used to wheel him in very carefully so that he looked as though he was in charge. And then they made sure the cabinet meetings didn't last, but they were very, very few meetings. And a few senators visited him when he was in his sick bed, and he put up a good performance, and they thought he was compos mentis. He may have been, but physically he was a wreck. And actually he outlived his successor, but he was in no fit state. Anyhow, that's a totally different topic. But the strength of the presidency is the main thing that I think I have to emphasize there to your friend Hector.
Okay. Next question submitted by Rob, another angry libertarian.
Oh, yeah.
Why would anyone have any respect for a document that was the result of a power-grabbing betrayal by the statists? Again, when he says statists, he means people that are obsessed with government control and federal government control. By the statists trying to centralize power for their cronies. To be honest with you, I'm not even sure exactly what he means by that, but yeah, that was his question.
I don't think that was actually what happened, because there was a constitutional convention, and a number of the people there were very much not statists in the sense that he's talking about, but state-minded in the sense of individual states, states' rights, like Thomas Jefferson, although people think that he, maybe he was instrumental in making the central government stronger. George Washington. There was a big debate about exactly, for example, how you should even address the president. Should he be Your Excellency? They were thinking of on the lines of foreign heads of state. But in the end, what won out was a very simple Mr. President. Mr. President. And I think it is very, very carefully balanced between the executive and the legislature, and also to some extent still between the federal and state governments. State governments still had and still do have quite a lot of power, but as time has gone by, that power, the power of the individual states, has definitely diminished. There's no doubt. But compared to the earlier constitution, the pre-federal, the confederation, yes, it was more centralized, but that was necessary to make one country out of it, because that previous constitution was actually chaotic. It wasn't a country, and it wasn't working well. And this was recognized by people like Washington. I don't think Washington was a great power grabber. Everyone knew that he had to be the first president, when he was taller than anybody else to begin with. And he'd won the war for them, after all. He was a regular British Army officer prior to that, but he became imbued with this idea. He was part of the elite. As I said, he was the richest man in America. They were all part of the elite, and they wanted their own country.
Maybe that's what my friend is getting at. Now that you're saying this, maybe what he meant by cronies was the fact that they were the elite of the time.
Oh, they were the elite. They wanted independence from Britain because Britain wasn't prepared to listen to them.
Mm-hmm.
Had Britain thought of the idea of dominion status, which came later with Canada, or representative government, or what's later called responsible government, which is more independent, I think America could have remained part of the British Commonwealth. And like Canada, they only thought of that later, and it came to pass in 1867 that Canada was given a good deal of independence from Britain. And later came Dominion status, that came much later, 1936, 1931, with the so-called Westminster, Statute of Westminster, where countries like Australia, New Zealand, South Africa, and of course Canada, later India, became dominions, which meant they were virtually independent, but under the crown. So the crown was just a nominal thing. The Queen to this day is the Queen of Canada. She's the Queen of Australia. She doesn't have any power there anymore. She has probably a little more power in Australia, as it turned out a few years back, than she had in Britain. She has no real power in Britain. But it was a unifying sort of factor, and they had their own independence. And America could have been like that, would have been similar in a way to what eventually happened, only it wouldn't have been a complete break from Britain. And in 1812, Britain wouldn't have burned down the White House.
Okay.
And caused President Madison to scuttle away.
Dr. Arnheim, believe it or not, we have come to the final question. Okay. So this is submitted by Skip. Now, I really don't know how to describe Skip other than he's one of the most interesting people I've ever met. So his question is very simply, why didn't it work?
Why didn't what work?
The Constitution. Now, I did not ask for negative questions. This just kind of happened naturally, but this was their questions, and that was Skip's question.
I think it has worked, actually.
Okay.
But of course, it's had its ups and downs. It's worked in the sense that, whether because or in spite of it, or got nothing to do with it, America has become a great power, or at the moment probably the only great power in the world, probably not for long. But whether that's anything to do with the Constitution, I don't know. But I think the Civil War certainly was something that could have been avoided and should have been. I don't quite know why Abraham Lincoln is given such a tremendous amount of credit. Even Trump was always invoking the name of Abraham Lincoln, who frankly I think is one of the worst presidents ever. That war could certainly have been averted. Both his predecessor and his successor, who are both regarded as failures as presidents, I believe were better than him. Buchanan, whose name is now practically forgotten, James Buchanan, who at the last minute, literally on the last day of his term, came up with a constitutional amendment which was a compromise on slavery, which even Lincoln accepted in his inaugural address, his first inaugural. He took it for granted that that would be passed. It wasn't, because the southern states didn't trust Lincoln and they seceded. But Buchanan came up with that right at the end. Normally a president isn't involved with constitutional amendment, but he signed it. The first time a constitutional amendment was ever signed by a president, then Lincoln signed his one. But presidents aren't normally involved in that. And Buchanan left it far too late, obviously. And as for his successor, Andrew Johnson, I think he was the wrong Johnson to have been impeached. I think Lyndon Johnson should have been the one to be impeached, not Andrew Johnson. Andrew Johnson was impeached because he was the wrong party. The reason he was vice president was because he was a Southern Democrat, and because Lincoln was afraid of losing the election. And so he got Johnson in on the ticket, never, of course, expecting to be assassinated, stupidly, sitting there in an open box in the theater right on the border of the South. What an idiot. And Johnson tried to mitigate the what came to be called Reconstruction. Not Reconstruction at all, it was suppression. I think both of those presidents were better than Lincoln, who was basically a warmonger, in my opinion. And the vice president of the Confederacy, whom he knew from Congress, they were both Whigs in Congress together long before the war, tried to approach him many times to talk peace. He wouldn't even see him, wouldn't agree to meet.
Wow.
So that was a very bad mistake and a very bad break in the Constitution, I believe. But the country picked itself up and went from strength to strength, particularly after, well, I suppose you can say in the late 19th century and then in the 20th century, and of course being basically the power broker in the world in both the First World War and World War II has meant that America has been very successful. So I wouldn't say the Constitution has been a failure in that respect. What better Constitution could there have been is another question. I don't know. I think, as I said at the beginning, one of the things I would have done is to split the position of head of state and head of government. I think that would probably be sensible, but that's a minor thing. And it has worked very well in Europe and in Asia and many other countries throughout the republics as well as monarchies, where the head of state is above politics and doesn't have any power, but has a certain respect, so that if you dislike the government, you don't attack the head of state, you only attack the head of government. But that's a minor point. Okay, so we're wrapping it up.
Yes, definitely. Well, I can't thank you enough for your time today and for hanging in there for almost 3 hours now. So I would love to have you back on at some point in the future if you're game for that, because I'd love to go over the Commerce Clause, the War
Yeah.
Powers Act, state nullification, jury nullification, and more of the amendments. But unfortunately, we can't do that today. I want to thank you so much again. And I want to strongly encourage everyone to go buy this book, The U.S. Constitution for Dummies. Give me just a second. Let me make sure that this is, there you go. U.S. Constitution for Dummies.
Second edition.
Not only do I recommend people buy it and read it, I recommend people read it every year so that they can keep these ideas fresh in their mind. Yeah, definitely. So go do that. And thank you again, Dr. Arnheim. Before I let you go, though, please let the audience know where they can find you and follow you.
Oh, yes, that's a good point. I think the easiest thing, actually, I mean, I do have a website, but I never use that. The easiest thing is an email address. My sort of folksy email address is Dr. Mike01, all spelled out, D-O-C-T. There's no way you can show it on the screen. Well, perhaps you can in the final. Dr. Mike01, D-O, all spelled out, D-O-C-T-O-R-M-I-K-E 01 @gmail.com.
Perfect. So reach out to Dr. Michael Arnheim if you have any questions or if you need to contact him for anything. I'm assuming you're not a big social media guy, which is good because I spend way too much time on social media. So thank you again, Dr. Michael Arnheim. Let's do it again soon, okay?
Thank you, John.
All right, take care.
Thank you, everyone, if you're still awake after all this.